And you're welcome back. And it's off to judicial matters, where the trial of the leader of the Indigenous Persons of Biafra, Nnamdi Kanu, has been adjourned to May 21st for the continuation of the cross-examination of the second prosecution witness. Justice James Omotosho of the Federal High Court in Abuja adjourned proceedings after admitting fresh evidence tendered by the prosecution. Our correspondent Joshua Imarayi reports from the court. Take a look.
The Federal High Court in Abuja on Wednesday admitted fresh evidence tendered by the prosecution team allegedly linking the defendant to the killing of former presidential aide Ahmed Gulag. Justice James Omotosho admitted both the medical report and the death certificate of Gulag following the no objection plea from Kanu's legal team. The documents were presented by the second prosecution witness, codenamed Triple B, who also submitted a police report from Owerri alleging Gulag was killed by suspected members of IPOB. During cross-examination, the defense team led by Kanu Agabi challenged the credibility of the video evidence obtained during Kanu's detention by the DSS. The defense raised further concerns over Kanu's alleged solitary confinement and prolonged detention. However, the witness maintained that he had no knowledge of Kanu's well-being, saying he acted solely on directives from the Attorney General's office. Under intense questioning, the witness admitted he did not draft the charges, had not arranged a meeting between Kanu and his accusers, and could not confirm when the charges were amended. While Kanu's lead counsel denied any restrictions, the judge warned against misinformation on social media, cautioning lawyer Aloy Ejimako over an unverified post.
The cross-examination of BBB started today and went on smoothly, but the defense got to a point where they needed documents to confront the witness, and those documents have been applied for. The CTC have been applied for, but not obtained yet.
The court further adjourned the trial to May 21st and 22nd for further cross-examination of the second prosecution witness. In Abuja for News Central, I am Joshua Imarayi.
And now to discuss this, we're joined by legal practitioner Sam Amadi. Dr. Amadi, thanks so much for joining us. We appreciate you for coming on. Let's just get started. What are the legal implications of the adjournment of a high-profile case like this on to May 21st to June 2nd?
Well, the judge has discretion to adjourn cases, but again, constitutional requirement is that accused person should be tried quickly. Part of fair hearing is also the right to be tried quickly. Already, that has been compromised, not by this judge, but by this is perhaps the longest running criminal trial in Nigerian history. One of the longest running, if not the longest running, in terms of the time he was arrested, the time he was on bail, the time attempts were made to kill him, as he alleged, and the time he flew out of the country and arrested and detained till now. So already the presumption of innocence works today so that you have to try accused persons quickly for two reasons. One, so that they do not spend a lot of time in detention or with, even if they're on bail, with the notion of jeopardy around them. And then if they're found innocent, you can't compensate for those long years of detention. And secondly, because the evidence also are fresh, and the state does state interest in quick trial, because it's both for the purpose of defense and purpose of prosecution. But as you can see from the proceeding, this case has so many knotty areas, knotty issues, the issues of interdiction, the issues of illegal arrest, the issues of many orders of court not being complied with. And now, for the first time, I think, we seem to be making real progress. So even at that, by now, there should be no adjournment on the basis of non-provision of documents. Everything should have been uploaded. When an order for a document is given, it should be DSS and whoever, all those in control, should make sure that those documents are in, so that we can just take a couple of months and get this case disposed. Not just for the legal issue, but also a lot of political outcomes seem to hang on this case, particularly the fragile state of security in the Southeast.
And how does this court determine the admissibility of evidence during the cross-examination of a prosecution witness?
So I didn't get the question. I said what?
I'm talking about the admission of this evidence as during the cross-examination, I beg your pardon, of a prosecution witness. How did they determine whether or not it's admissible during a cross-examination of a prosecution witness? Because that's what's really causing this to be extended, right?
Part of it is that, look, every evidence that is produced by prosecution or defense, or defense puts through cross-examination, has to be, the first question to decide is whether it's admissible. And generally, relevant evidence are admissible, especially if they also are both relevant as well as produced through proper procedure. And in this case, the court will, if there's an objection, and in many cases, the defense didn't object to the medical reports because, of course, their probative value in terms of determining the guilt or the rise of Nnamdi Kanu is not that strong, so they wouldn't argue. But if it's evidence that is very dangerous for their case, and evidence that its relevance is far-fetched, or its production, circumstances concerning the evidence is so that they're incriminating or wrongly obtained. For example, if evidence was obtained from the witness or from the accused persons illegally, in virtue of their right, they all evidence under duress, defense will object. Those are part of the fair hearing procedures, and they're not the things that lead to undue delay. So it's proper to try to present evidence or to challenge evidence either during prosecution leading the witness or during cross-examination, as long as those objections are timely handled by the judge. And in this case, I think so far the court is doing well in managing the complexity of this case.
And one has to ask at this point whether repeated adjournments can be seen as a violation of the defendant's right to a fair and, most importantly, speedy trial.
Of course, they have been construed. If the adjournments are unduly long, for example, at the instance of prosecution, then some judges have made criminal trial to struck the case out because first, it clogs the court's docket. Criminal trials are priority. You can see it's like a daily trial. And so if because of shortness, sometimes prosecution does not have a good case or they have not prepared their case. And so they use the court to stall and go on fishing expedition looking for evidence to nail accused person. The court, as a fair arbiter, could interpret that as a fair proceeding, where it looks clearly that the prosecution is already or does not have a good case, and so using, especially when accused persons are not on bail. I mean, if an accused person is held in detention and the prosecution is shoddy in their preparation, and it seems to the judge that the delays are undue, and of course the delays seem to be orchestrated at the behest of the prosecution, either to look for evidence or to make up for the incompetent prosecution, the court can interpret those delays as prejudicial to fair hearing in the constitutional protection for accused persons. Due process clause under constitutional protection in criminal case includes undue delay, and when that happens, in some cases, judges may strike out the case or even dismiss them for want of fair and diligent prosecution.
Well, all eyes are on the courts for May 21st to see how this continues to unfold. I must say thank you, Dr. Amadi, for taking out the time to join us. Dr. Sam Amadi is a legal practitioner, giving us a bit of insight following the adjournment of Nnamdi Kanu's case.